The proposed definition of disability is based on the definition that has been used in both Ireland and Australia, and it has been tried and tested for the past 25 years. It has proved itself to be both workable in practice, as well as compliant with the UN Convention on the Rights of Persons with Disabilities. The broad definition aims to protect as many people as possible from discrimination, but it's important to note that just because a person comes within the terms of a definition does not mean that they can bring a legal claim. It is also necessary to show evidence that you are actually discriminated against. It is sometimes argued that discrimination legislation should only protect those people who are really disabled, but that's an incredibly problematic position to take. How do you decide if somebody is disabled enough? So, for example, some jurisdictions, like the United Kingdom, require somebody to be affected to a particular degree. Now, the impact of this is that it increases complexity. For example, in the UK, the government guidance document on how to decide whether a person has a disability runs to 58 pages on this issue alone. The reality is that that kind of definition or that kind of approach adds a layer of litigation and cost. You have to litigate the question on disability as well as the substantive element of the court case. The key point is probably that the type of definition proposed has been used elsewhere for a long time and to good acceptance. It hasn't led to frivolous claims or to a litigation culture. Businesses still operate successfully in both Ireland and Australia. They've just had to adjust their practices to some degree to comply with the legislation.